Hello. We had to cancel our estate planning basic workshop this month due to the pandemic, so we decided to go ahead and record one for you, just in case you wanted to see it. Right now, when we think about estate planning, we're thinking of two things: what happens when you die, and what happens if you become incapacitated. So I usually focus on the incapacity part because that obviously has more of an impact to you. So one thing that we look at is your durable power of attorney, and that's a document that we put in place to make sure that you name someone as your agent to be able to stand in your shoes and make all of your day-to-day decisions. In Florida, your durable power of attorney is going to be effective as soon as you sign it. So you sign it today, you give it the document to the person that you name, which we call an agent or an attorney in fact, and they can start acting for you. Most of the time, we don't want those people acting until we're actually unable to act for ourselves, usually because we're incapacitated. So with that durable power of attorney, you're naming someone to be your agent, and then we're going to tell you to name a successor. And usually I'm going to recommend that you name someone that can be trusted to do what's in your best interest when no one's watching. So you don't want to just name your next door neighbor or your home health aide. You want to name someone who's going to be able to manage your assets, who are going to pay your bills, and who are not going to do anything that just benefits them. So your durable power of attorney in Florida is very lengthy, it's very detailed. It's going to just basically detail out all the powers that your agent has. And a few of those powers would be something silly like, social media accounts they can manage, doing funeral arrangements. They can also deal with your pets, change your mailing address. But the more important ones necessarily that we might have to do is going to be selling your house or dealing with your retirement accounts, writing checks off your account. So we don't want to put your daughter on your bank account to write checks because you've just made her an owner. We don't want her to own those assets today for a couple of reasons. Those are her assets, so if she decides tomorrow to take it out, she could take all the money out. Obviously, we don't think our kids will do that, but it's an option, it's an ability that they have. Now, the other reason why we tell you not to is, let's say you have more than one kid. You just name that daughter on the power of attorney on the bank account. So that person is not a power of attorney, she's an owner, so when you die, that account just goes to her. That means she does not have to share with her siblings. So really be careful on when you're titling accounts. We do not recommend putting anybody on the account that's not a true owner of that account. Let the durable power of attorney come into play if you're unable to act for yourself, which will allow that person that you name as your agent to be able to stand in your shoes and make all of your day-to-day decisions for you. Like I said, anything to do with your finances, your expenses, canceling your cable, all of that is going to be covered through the power of attorney. And they can't act unless you give them the document. So, if you're concerned with them stepping in too soon, don't give them the document. Make sure that you know where it's at, but then keep it until you're feeling its time is ready, or make them come to the attorney, and then we make sure that you're actually incapacitated or you've given us permission at that time to release it. The other part of incapacity is obviously your health care. So who can decide medication, treatment, going to different doctors, maybe not having a surgery? And that's going to be your healthcare surrogate. So in Florida, we do this healthcare surrogate. Other states may call it a healthcare proxy. But the idea is still the same. You designating the person that you want making medical decisions. It could be something that's just temporary, or it could be where they're making a decision that may end your life. So you don't want to be like, just name anybody on that. You want to name the person that can handle tough end-of-life decisions, not someone who's going to get super emotional over it, but also you want to make sure that those people that you name understand what you want as far as end of life. Talking about quality of life, how far to go to keep you alive. If you start having health issues and you can't live independently, where would your ideal place be to go live? Would it be with one of your kids? Would it be somewhere in the villages, an assisted living? So again, looking at the big picture of your healthcare situation will be helpful to explain that to your children or your loved ones or whoever you're making as surrogates in those situations. Then you have the living will, and in Florida, our living will basically says in the event we're in a vegetative state, end-stage condition, or terminal, so you're one of those three, and there's no chance of recovery, and two doctors agree, you're saying you don't want to be artificially prolonged. Now, the living will is what the hospitals tend to ask for every time we go in. It's just a one-page form in Florida, and so that's something that you would give if you were going to the hospital. It's rarely put in play because, again, you have to meet that criteria. But again, your healthcare surrogate can make any end-of-life decision for you, or medication change, or doctor change, or not having a surgery. Now, HIPAA authorization is another form that you see us do, and that's basically just allowing your people named, so anybody on there, so like my parents have 7 children, all 7 of us are named, so if any one of them, one of their kids want to talk to the doctor, see how they're doing if they're in the hospital or rehab, that's going to let us have access to that. So when you look at your HIPAA, it's just a release of information. There's not an order of priority. It doesn't give them the ability to make decisions. So those are our incapacity documents. Now what happens when you die? You're either going to have a will or a trust. If you have neither, then you're going to be called dying intestate. And if you die intestate, meaning without a will, then the state that you're a resident in will determine who those beneficiaries are. Your state, the state of Florida, is not going to get all your assets. They have a statute that says who's entitled to your assets. Now, when you have a last will and testament, it does not avoid probate. The probate court only gets involved if there's an asset in your name alone. So if you have an asset that just says your name, so for example, Amy Pittman, then that asset is going to be frozen. It doesn't matter what the value is. So in order for my husband Josh to be able to get access to that account, he's going to have to open a probate, submit my will, which would identify him as the beneficiary. And then the probate court will enter an order transferring the asset to him. Now that's a simplified version. But again, don't think that a last will and testament is going to avoid probate. It just tells the probate court who the beneficiaries are, who you're going to name as your personal representative. Other states may call it executor. Now, a trust, people will look at that as a way to avoid probate. But if you're not going to do a trust and you're just going to do a will, then we recommend that you do beneficiary designations on your accounts. So checking, savings, a lot of those banks will allow you to do what we call a pay on death designation, maybe in trust for. If you have a brokerage account, stocks and bonds, sometimes they'll call it transfer on death, and that's you designated those beneficiaries. So if you only name one child as a beneficiary on that account, that's the only person getting it, even though your will says you have 3 children. So be very intentional about how you title your accounts and who you've named as beneficiaries, because that's who's going to receive your asset. Now with a revocable trust, the idea is people are trying to avoid the probate and they're trying to get those assets into one bucket. The trust will identify your beneficiaries. It also identifies what we call a trustee. So while you're alive, you maintain the same control over your assets. You can spend down to 0. You can do anything with changing the accounts, changing your house, but you have to make sure that when you open an account, like a checking or savings or investments, that you're naming the trust as the owner, or if you have a life insurance, that you're naming the trust as a beneficiary, so that when you pass, those assets are in this revocable trust. There would be no probate. And then the trustee would come in, and once they get a death certificate, we give them what we call a tax ID number. That's at the death of the owner of the trust, and then they would be able to have access to those accounts once they get a death certificate. So it's a very smooth transition as long as they know where those assets are. So you want to make sure you have a list of your accounts, how they're titled, so that way when your trustee steps in, they know where that important information is. And then they would be able to have access as a trustee. They then would cover your bills, put the house up for sale. Once they know all that's done, they would make the disbursement to your beneficiary. So it's doing it without the probate court. Now, everybody that has a trust also has a will. We call them pour-over wills, and it's just a backup plan. So let's say you never go into the bank to retitle the account. You die, it's just in your individual name. That one account is going to be subject to probate. It doesn't matter what the value is. So in probate, the value of the account will determine which level of probate we have, but in order for us to unfreeze it, we're going to have to open some type of probate. So again, the reason why you would do a trust is to get rid of that process, so everything is going to be part of the trust. And again, the trust may not be what you need, and that's where you need to talk to an attorney. I know we do complimentary consultations. I send out a worksheet so that I can determine what type of assets you have, the family dynamic, and then I can kind of give you an idea of what I would recommend, whether it's a trust or a will. Benefits of a trust, you usually hear people doing it to avoid probate in multiple states. So we have a lot of clients that live down here that also have a house up north. So to avoid probate in 2 states, they're going to have a trust that owns both of their properties. Maybe their beneficiaries are bad with money. We want to control how much they get, and when they get it, that's going to be set up in a trust. Beneficiaries that are minors, we want to control it until they are 25. That's going to be set up in a trust. So a lot of different reasons why you may create a trust. We definitely recommend you come in for a complimentary consultation, so we can sit down and figure out what works best for you, and then give you the guidance on how to put that in play. I hope this was helpful. Again, we'll start having our workshops again once this is over. But in the meantime, this should provide some guidance. feel free to, we are still open during this time, but on a limited basis. We're trying to do most of the consults through Zoom or phone. And then when we do our signings, it's on our front porch. So we are trying to be adaptable in this time of change, and make sure that everybody's taken care of. All right, have a great day.